Good morning, everybody, and welcome to Archer's first webinar. Thank you for joining us. I'm sure all of you now know Archer is a new boutique construction law firm. We formed earlier this year, starting trading on the 1st of June, and we're very glad to be welcoming you all here today to our first webinar. My name is Carolyn Porter. I'm a partner at Archer. I specialise predominantly in construction disputes, but I do also advise on various contractual terms and the risk allocation in different contract forms. Joining me today is Andrew Rush. Andrew is our senior partner at Archer. I'm sure most of you will know Andrew, and so he needs little introduction. I will say he used to be an engineer. Any of you that know him will definitely know that. And he's also listed in the Legal 500 Hall of Fame. So the clue is in his name, really. As our senior partner, Andrew has a wealth of experience in all construction matters. Today, we're going to talk to you about JCT insurance clauses. It's not the most riveting of topics, so apologies for that. I hope you have all had your coffee, but I do hope that you get some useful information from this morning, because insurance is always a key issue in construction. Just a little housekeeping before we begin. This is the first time we have actually used Teams for a webinar. Hopefully you can all see myself speaking, and also the first slide, which shows your presenters for this morning. If you can't see that, you should be able to alter your settings so that you can see the slide as well as myself. We are going to run through the slides this morning and then deal with questions at the end. We have already received some questions from some of you that we will deal with. However, if any of you have any additional questions that arise during the webinar, please do use the conversation button at the top of your screen. It looks like a small speech bubble, and you can type your question into there. All of the attendees on this webinar will be able to see your question in that conversation bubble. Don't let that put you off. But please do keep it clean. Also, just to note that this webinar is being recorded today, and by being present on the webinar, you are consenting to that. I recommend that you keep your video turned off, but that's personal choice. If you want to turn your video on, you can. You are automatically muted, so you will not be able to be heard by anybody in the webinar. So let's make a start. Why insure? Insurance gives a party protection should something go wrong either during or after a project. The majority of companies will take out a lot of insurance for a number of things, but not everyone insures. So, for example, councils have a pot of money set aside in case something goes wrong with one of their property portfolios. The key is that parties ensure they are adequately insured against their own risk allocation within any given contract. Parties may also be contractually required to take out certain insurances, especially if there are concerns that that party may not be able to pay in the event something goes wrong later down the line. Our talk this morning focuses on insurance clauses in JCT contracts. Under the JCT design and build contract, there are numerous acronyms used for the various insurances. Today, I am going to talk to you about EL, or Employers Liability Insurance, PL, Public Liability Insurance, NNI, which is sometimes referred to as Clause 6.5.1 insurance, which is non-negligent insurance, PI, which is of course professional indemnity insurance. MUI. Now, some of you may not have heard of this. In fact, I suspect none of you have heard of this because unfortunately this is one of Andrew's gags. MUI stands for made up insurance. It was just thrown in there to check that you were all paying attention. I have told Andrew that gags really don't work in webinars because you definitely won't get a laugh, but nevertheless, he persists. Andrew will then talk to you about CAR, which is contractors all risk, and then he will go on to discuss the JCT options and risk protection arrangements. This talk generally focuses on the JCT design and build contract, but the provisions for insurance are basically the same in all of the JCT suite. It's worth noting that in other forms, whilst contractors may not take on full design responsibility, there are still often CDP elements to the works, and therefore it's important that contractors ensure that those design elements are sufficiently covered with relevant PI insurance. I will come on to that in due course. Now, this slide on screen sets out the clauses which are relevant to specific insurances. Now, section 6 of the JCT suite deals with insurances. Now, as you can see on screen, you will note that clauses 6.1 and 6.2 set out the scope of the contractor's liability, be that for personal injury or death under 6.1 and damage to property under 6.2. Clause 6.3 then reduces the scope of that liability if option C applies. Clause 6.4 is then slightly different in that it goes on to discuss the scope of the insurance required by the contractor to protect the contractor against claims under clauses 6.1 or 6.2. The later clauses then describe various other types of insurance, such as the non-negligent insurance, professional indemnity insurance, and contractors all risk. I will start by looking at employers' liability insurance. So employers' liability insurance protects a party against liability for injury or disease to its employees arising out of their employment. So, for example, if a contractor's employee were to break his ankle whilst on site, meaning that he was unable to work for a certain period of time, in that circumstance, the contractor may find a claim against his employer's liability insurance. Now, employer's liability insurance is a statutory requirement. So all employers with one employee or more are required to hold minimum employer's liability insurance of £5 million. There are some exemptions to that rule in that public bodies are exempt. However, in construction, the vast majority of parties would be required under statute to hold that employer's liability insurance. Specific provisions in contract, therefore, are usually unnecessary because most parties already hold employer's liability insurance. However, it is mentioned briefly in the JCT. It's always worth considering as well whether the nature and scope of the project in question requires you or means that you should consider holding additional insurance above that 5 million minimum limit under statute. Moving on to public liability insurance, which is also sometimes known as third-party insurance. This covers liability for death or personal injury to third parties, so not employees, and also damage to property belonging to third parties, and that injury or damage must be caused by the carrying out of the works. So an example of this would be if scaffold were to fall onto a pavement and either injure a passerby or potentially damage a parked car. That is an example of when public liability insurance may be required. Public liability insurance does not cover damage to the works or to site materials. Public liability insurance is held on an events occurring basis. Claims will be made as an event occurs, and therefore the policy is not maintained after the project has been completed because it is simply not needed. The risk ends when the work ends. The level of public liability insurance required under any project should be set out in the contract particulars. And on this slide, there is a screenshot of the relevant clause that sets that out. The typical level of cover required for any given project is between £5 and £10 million. Interestingly, for all rail-related works, regardless of the scope of works or the contract sum, the cover required is 155 million. Why that precise figure applies, I am not sure, but apparently it is readily available. Moving on now to non-negligent insurance. This used to be known as clause 21.21 insurance. It now comes under clause 6.5.1 in the JCT suites. Now this insurance essentially does what it says on the tin. It insures the employer for any loss they may incur due to non-negligent damage by heave, movement or collapse. This sort of insurance is normally required for example, large basement excavations where the works are in close proximity to other buildings. It also may be required for large extension works. Non-negligent insurance is ordinarily not required, and therefore, if it is needed on a project, it must be specifically requested. And it can form part of a contractor's all-risk policy. Again, the contract particulars will set out whether non-negligent insurance is required, and the minimum amount of indemnity should be inserted within 6.5.1 as shown from the screenshot on the slide. Professional indemnity insurance is probably an insurance that most of you are familiar with. It covers issues that arise from professional negligence. Most commonly, this is from negligent design, but in construction, professional negligence can also arise from the negligent performance of any other professional services, such as surveying, contract administration, or project management. It is normally a requirement for all parties with any design responsibility, so most contractors and some subcontractors. It's also a requirement for all professional consultants, or at least it should be. PI insurance normally operates on a claims made basis, and therefore it will cover negligent events arising before the cover started, as long as the cover is in place at the point at which the claim is made. The term of cover needs to mirror the contractual liability period. So a contractual liability period would be 6 years for a contract signed under hand, 12 years for a contract signed under deed, or potentially 15 years under the draft building safety bill. If that goes through, the liability period will be extended further for certain projects. The level of PI and the duration of PI is set out in the contract particulars. It's important to note that the level of PI held does not cap your liability under the contract. Similarly, the duration of PI required does not necessarily mean that you are no longer liable under the contract. It is therefore key to ensure that you have sufficient cover for a sufficient period of time set out within these contract particulars. You may also want to negotiate a cap on your liability. If you are successful in negotiating that cap, it's important to make sure that your PI cover then mirrors that cap. These contract particulars also set out whether pollution and contamination cover is required. So again, that is something to consider on a case-by-case basis, and also consider the sublimit of indemnity for those insurances. The current PI market is precarious. Many insurers have withdrawn from the market because it was simply not profitable. As a result of this, premiums have shot up and they continue to increase. The Grenfell disaster is recognised as being a catalyst to the current PI market problems, and this means that cladding and any fire-related insurance is even harder to come by. When taking out PI insurance, it is critical that the correct level of cover is sought. Now, the terms for insurance cover can be confusing. I have set out on this slide 5 different terms that you may see in relation to PI policies, and you need to consider each one and determine what is appropriate for you. So the terms each and every claim and any one claim, so that is the first 2 bullet points on this slide. These terms effectively mean that the limit of cover is the total amount insurers will pay out in the term. So any previous claim on the policy will not impact on your cover. They are irrelevant. The second 2 points on the slide, being any one claim and in all, and also aggregate, mean that the limit is the total amount the insurers will pay out in the term. So any previous claims may impact on the cover. Now, it's important to note that phrase any one claim and in all actually means aggregate. Again, confusingly, the last point on the slide, an aggregate subject to automatic reinstatement, is actually similar to an each and every claim type arrangement. This actually means that after making a claim, the level will be reinstated. So effectively, it is an each and every claim. But for policies of this nature, it is important that you check the terms carefully to see if there are any exceptions on the reinstatements. We often get asked what level or type of PI is appropriate. The quick answer to that is that it depends entirely on the risk profile of the job. Moving on now to the Joint Fire Code. The Joint Fire Code is the joint code of practice on the protection from fire of construction sites and buildings undergoing renovation. So the code was published jointly by the Construction Confederation and the Fire Protection Association, and it is widely recognised as best practice. It has been around since 1992, and it is currently found within Section 6 of the JCT 2016 suite. The code provides guidance on fire and the prevention of fire, and it contains a series of questions which should be completed to establish whether fire precautions on site are adequate. Now, the code generally applies to contracts that have a value in excess of 2.5 million, but it can apply to lower value contracts if the project is high risk or if that contract forms part of a larger project. Don't simply tick the box. If you do and then you fail to comply, it can result in an insurance policy being cancelled or withdrawn. However, conversely, if you do comply and confirm that it applies to the project, it can reduce your premiums in time. The contract particulars will set out whether or not the joint fire code is to apply. It also stipulates who will bear the cost, if any, of complying with any amendments to the joint fire code. That is everything from myself. I will now pass over to Andrew to deal with contractors all risk insurance and the remainder of the talk.
Oh, seamless moving of the laptop. There you go. Okay. It was a bit strange because actually when you're looking at the slides you can't actually see your own face, which may be a blessing in some circumstances. But anyway, right, contractors all risk policies. That slide shows an expression taken from the JCT. So an all risks policy, well, quite simply is a policy that covers all risks, but in simple terms, it covers against loss or damage to work executed and site materials. The point about an all risk policy is a very specialist policy. I will come on to lots of comments about joint names, composite, insured, etc., and what subrogation rights mean and rights of recourse mean, but it's a very specific policy. So you can't, it's not a high street type policy. You need specialist insurers to get you the policy. One of the things to talk about, one thing to understand about an all risks policy is it is what it says. It covers all risks minus any specified exclusions. Unlike, say, your average policy, which specifies exactly what it does cover, all risks covers everything unless it's excluded. And that's basically because you need to be able to insure damage to the works for any risk that might occur, unless, of course, the policy expressly accepts those risks. That's not too difficult to say at this time in the morning. Right, so just a bit of basic understanding of insurance terms, which I have to say is not well understood. So a joint names policy is a policy in the names of two parties or more, with one loss payee. So in other words, one person gets paid the money out of the policy if a claim is made. So the loss payee is the party who is paid. And if you look in a JCT contract, certainly for options A and B, it's specified to be the employer. You can have amendments to contracts that might make that the funder, but in simple terms, it's not the contractor. A joint names policy is not the same as a composite insured joint names policy. The key point is a joint names policy can be vitiated, another insurance expression, but can be vitiated by one party, in other words, breached by one party, and then therefore no longer applies. A composite insured policy cannot. And the relevance for that is if the contractor, for example, fails to maintain the premium on an all risks policy, the employer is still covered. So it's quite important that you recognise the difference between a standard joint names policy and a composite insured policy. In the insurance world, vitiation is basically another word for breach. So a policy can be voided if there is a breach or a vitiation of the policy, and the obvious way that that policy is vitiated is by not paying the premium. Subrogation is the expression used where the insurer can take over the rights of the insured. Subrogation, I once looked at this when I was a trainee in London. Subrogation comes from Latin subrogare, which basically means take the place of. That's about as much Latin as I know, which is what, when you hit if you have a car accident, your insurer takes over your rights, your insurer subrogates your rights and brings a claim against the other party if that's relevant. The final point is being noted on the policy. Now, lots of people say, I want to be noted on the policy. That doesn't give you very many rights. It basically means you get notified of when the policy is no longer in effect. So that is not what you want if you want to be an insured party. What you want to be is a joint named, and obviously preferably under contractors or risk, you want to be a composite joint named party. There are also some other expressions that you will find in JCT. Accepted risk is, as I explained earlier, an all risk policy is everything unless it's an accepted risk. I did have a quick look this morning, and if you look at the expression for accepted risks, it is basically everything to do with nuclear power and ionization and, the world about to come to an end. So if it was an accepted risk, we probably wouldn't worry too much about our insurance anyway, and we'd all go home and wait for the inevitable. Specified perils are types of risk. The relevance of a specified perils definition is when we come onto existing structures are only insured for specified perils as opposed to all risks. The works are insured for all risks. Existing structures are insured for specified perils. In practice, specified perils covers flood, fire, lightning, storm. It covers by far the most likely things that are going to occur to a building. Pool Re is the government-backed terrorism insurance system. It was much more relevant in the sort of early 90s when there was, not that regularly, but there were terrorist activities in London in particular. I have to say it's still required as a default, but it does seem probably a bit out of tune. The other comment you'll find about terrorism cover in a JCT policy is they do have a terrorism cover expression. That's for cover over and above the Pool Re policy, because the Pool Re policy is a relatively restricted policy. That said, it's unless you've got a particularly high risk policy, the use of terrorism cover seems somewhat out of date. Just to recap before I get onto the nuances of A, B, and C, a JCT contractors all risk policy is a joint names composite insured policy. For any significantly funded project, you will find that the funder also is required to become an insured party. A JCT contractors all risk policy has no rights of subrogation. So in other words, if the contractor burns down the building, the insurer cannot bring a claim against the contractor because there's no right to subrogate the employer's rights. There are no rights of vitiation, which in other words means that if the policy isn't paid, it still kicks in. And that is important for the employer side and the funder side. The other point about a contractors all risk policy is it covers all subcontractors involved on the scheme. We often find a situation where subcontractors are required to take out their own all risks policy in circumstances where the contractor's got an all risk policy under the main contract, which already covers the subcontractors. Now, there's nothing fundamentally wrong with having two lots of insurance, but it does seem somewhat unnecessary. The other point to make about a contractors all risk policy, it does not apply to professionals, so it does not cover design issues. That's what your PI covers, and professionals are not covered by a contractors all risk policy. And as I've said earlier, the loss payee, the person who gets the money if a claim is made on the policy, is the employer. Under option A and B, they are required to pay the contractor to repair, effectively rebuild the works. Under option C, there is a right for the employer to terminate, should they so wish. having been paid the insurance. You will see in most JCT contracts, contract particulars like this, and I'll come on to when you use A, B, and C, but I would stress, do not put C if you are a project manager or employer's agent and then just think everything's fine, because it won't be. You need to then have a very detailed discussion with the employer and understand if option C is available. You'll see reference there to percentage to cover professional fees. So the all risk policy also covers effectively the cost of redesign. That is typically stated as 15%. That's quite high, but it could be anything from 10 to 15. And there is one additional box in the 2016 one about option A and annual cover, because most contractors, in fact almost all contractors, have an annual contractors all risk policy that is designed for use on option A contracts. I'll come on to the C1 replacement schedule, as it's called, shortly. So there are three options: option A, option B, and option C. In practice, there are only actually two that are ever used, option A and option C, and I'll come on to why. Option A is the most common form of contractors all risk policy. So an option A contractors all risk policy is the policy used for a new build construction scheme, not a refurbishment scheme. So basically any new build that is not a refurbishment scheme will typically use option A. Option A is contractors all risk policy taken out by the contractor. So it's exactly the same expressions. It's a joint insured composite policy, but in this case, it's taken out by the contractor and insures both the employer and the contractor. As I've already said, it covers all subcontractors. Under the option A scheme under JCT, the loss payee is the employer. So the employer gets paid the money to then repay the contractor to rebuild it. It's a joint names composite insured policy with no rights of subrogation. Hopefully you're getting the message on that final point. That's option A, and most people are pretty clear about that. There's an annual policy typically for most contractors that covers option A, covers your new works policy, not a problem. Option B is exactly the same as option A, but with the employer taking out the insurance rather than the contractor. So everything is the same. The loss payee is still the employer, but it's just, this is a situation where the employer is in a position to take out the contractor's all risk policy. I'm confused as to why this is still in a JCT in circumstances where most, if not all, contractors have an annual contractors all risk policy that would cover the situation where option B would be used. I do accept that you get some project insurance policies, but then in that case, option A and B are not appropriate. The thing about option B is very few clients find it straightforward to take out contractors all risk policies, partly because clients don't do much building work. So therefore, when they ask their insurer for a very specific construction policy, the premium is enormous if it's even possible. The reason for the picture is their mods. And one of the few people who can actually take out option B insurance is the MOD. It takes a while and it's early in the morning, but there is logic behind that picture. So you will find in rare exceptions, particularly for very large employers like the MOD or other government bodies, there may be an option B insurance in place. It's the same as option A, other than the employer's paying the premium rather than the contractor. Easy bit. Let's move on to the difficult bit, option C. Now, option C is the JCT's default for where there is a refurbishment type scheme. The key with option C is to understand there are two types of insurance. You are insuring the existing structures and you are insuring the works. And you have to keep reminding yourself there are two types of policy being put in place. The existing structures policy is required to be taken out by the employer. It is a joint names policy. It is a composite policy, but it only covers specified perils. So it covers flood damage, fire damage caused by the works to the existing structure. You can understand the logic. If you're repairing floor 6 in a in a block of flats and a flood occurs, it is likely to cause damage to floor 5, 4, 3, 2 and 1. The issue with existing structure policies is, can the employer, who is required to take it out under the contract, actually obtain this in the market? The employer, depending on the nature of the employer, whether they're a tenant, freeholder, etc., may or may not be the person who has currently got the buildings policy. So it's complicated depending on the nature of the employer, the role they have in relation to the existing buildings policy. So the contract needs to reflect the actual position. I've put there the employer is very unlikely to be able to get a joint names policy. I'll come on to that, but it is difficult for any employer to get a joint names composite insured policy for an existing structure. So what JCT has at least done, and I'll come on to it in a moment, is recognised that this is a difficulty. So they've come up with what they call a C1 replacement schedule. Now the C1 replacement schedule is basically there to explain, in a situation where the employer cannot take out the standard policy, what is being taken out. The problem is when you get to the works. So again, remember these are two distinct policies. The existing structures is one policy, the works is the other. Under JCT option C, the employer is required to take out a joint names composite policy for all risks for the works. The employer has no experience of carrying out works, and the employer will find it very difficult to obtain an all risks policy for the works. A bit like, as I've said earlier, the reason option B is so infrequently used is because employers find it very difficult to get that form of policy. JCT hasn't recognised that this is called C2 in JCT, but it hasn't recognised that this is as difficult for the employer, if not more difficult, than C1. Also, I remain confused as to why the employer should be taking out a joint names policy for the works when the contractor has an annual policy that is a joint names policy for the works. If the contractor is going to maintain this policy rather than the employer, that's fine, but the contract needs to be amended to reflect the actual position. So you've got two types of policy, both that are meant to be taken out by the employer, both that the employer will find it extremely difficult to take out. One that's been recognised by JCT as being very difficult and one that isn't. So let's move on and let's explore this a bit further. So as I've said, C1 and C2 under a JCT contract, C1 talks about the employer taking out a joint names policy in respect of the existing structures for specified perils. So it's the employer taking out that complicated joint names composite policy for the existing structure. So effectively taking out an additional policy for the existing structure to cover flood or fire damage caused by the works. If you notice at C2, the employer is also required to take out the works policy, i.e. to cover the works, even though the contractor probably already has that in place. So that is the way JCT defaults. As I've already said, if you are a project manager, an employer's agent, do not simply say, and everyone does it, oh, it's a refurbishment project, option C, tick the box. No one does a great deal more. If you don't then talk to your client and say, this is what you need to do, have you got this in place? You will be held to be negligent because you would not have given them the correct advice. So let's follow this through. An employer is meant to take out option C insurance to the existing structures and to the works. A fire occurs, which causes damage to some of the works and causes damage to some of the existing structure. Now the employer, and I have had this before, we had a contract where the employer said, where the contract said the employer would take out option C, but no one told the employer, so they hadn't taken out either. So the employer's insurer will say, well, I want to bring a claim against the contractor, and the contractor will have an absolute defence because he'll turn around and say, no, hold on, under the contract, you're meant to have a policy in place that says in the event there is a fire, you take out the works policy, which covers me because there's no rights of subrogation, and you take out the existing structures policy, which covers me because there's no rights of subrogation. So the employer is sat there, and perhaps his insurer then refuses to pay him, unable to recover the money from the contractor. And all this is very interesting, but who is the employer then going to look at? It's going to look at the advisor who didn't tell them what to do with the option C insurance. So if you have projects with option C insurance, it should be a big red flag, and you need to think about the insurance very specifically. This is a JCT footnote. It's a dull slide, but it's at least evidence that JCT has recognised that option C is very difficult to obtain. So it makes it clear the employer is required to take out a joint names policy for all risks insurance, but has this paragraph C1, which is the alternative if they can't. It says some employers may not be able readily to obtain the joint names cover under C1. That is a massive understatement. Almost all employers will not be able to readily obtain the joint names cover under paragraph C1. So in most cases, if you have a complicated building with a refurbishment, you're going to need some specialist insurance advice. I think one of the footnotes, may not be this one, it does actually say, speak to your insurance provider. So although it does say, should consult your specialist insurance advisor. So what JCT is saying is, look, you need to go and talk to your insurers. What I would say is finding insurers who readily understand contractors or risk policies is difficult. There are some, and there's some very good ones, but your average insurer will not understand a contractors or risk policy. The guy on the high street will not understand that. So you need to obtain specialist advice to make sure you're covered. This is the start of the question section, effectively, because I'm going to give you 2 examples so you can see how this might work. So let's assume you've got the freeholder owns a multi-level building, so 6-7 stories. The leaseholder who leases floor 3 is having their fit out done. So the leaseholder is the employer. The leaseholder will typically only have an internal demise only, will only be responsible for the internal, will not be responsible for the structure. This is a standard fit out job using option C, JCT design and build. Default, because you're the employer's agent, you're the project manager, you tick the box option C. The default is the employer takes out the existing structures policy and an all risk policy for the works. What happens? Because we've already discussed that the employer is going to find that difficult. Well, the freeholder is the only person who can amend the existing structures policy, because they're the only person who is currently responsible for obtaining that policy. The freeholder is extremely unlikely to agree to a joint names composite policy for the existing structures when it relates to its leaseholder. The leaseholder will not be able to get an all risk policy for the works at all, because it's not a contractor and has no track record. So putting those 3 things together, you have a employer under the contract which has an option C ticked where it can't obtain either of the 2 relevant insurances. So what do you do? Well, in a perfect world, the freeholder will obtain a joint names composite insured existing structures policy, but experience suggests they don't. And as regards to the works, the contractor uses its all risk policy. So deal with the works first. The contractor's got a policy that covers that. So change the contract such that the contractor is responsible to take out the all risk policy for the works. As regards the existing structures, it's complicated, because if the freeholder cannot or will not amend its existing structures policy and to pay the additional premium to cover the requirement under the contract, you've got an uninsured risk. There is a sort of way around this in this example, because the freeholder's building is actually a third party's policy. The freeholder is not the employer under the contract. So your public liability policy will work in this scenario and will cover damage to the existing structure because it's a third party's property. However, you need to be careful on 2 fronts. There are certain clauses called care, custody or control exclusions, where third party or public liability policy will not kick in if you are responsible for control of that building. And there's an argument that if you're doing work in a building, the public liability policy won't kick in. Also, if you've got a very big building and your public liability policy is capped at 5 million and there is more than £5 million damage caused to that building, then there is a gap as to cover. The issue is it's complicated. I am not an insurance advisor. If you have this sort of scheme, you need to make sure you deal with your insurance advisor and make sure you are covered. Let's look at example 2. Very similar, but the freeholder is the employer. So there's no leaseholder involved, there's a freeholder. So exactly the same situation, freeholder needs to take out the policies rather than the leaseholder. What happens? Well, it's a bit like the last one, but more difficult, because the freeholder, as I've already said, is unlikely to be able to get a joint names composite policy for the existing structures in any event. And the freeholder is also unlikely to be able to get an all-risk policy for the works. Solution. Contractor uses its all-risk policy for the works. It's got it, it's annual, just use it. But the freeholder will struggle to get the existing structures policy. In this scenario, you can't rely on your public liability policy because the property being worked on is the property under the contract. So it's not a third party's property. The solution is complicated. I'm not suggesting that picture in any way demonstrates who you should go and talk to, because I'd be very surprised if that particular insurer is sufficiently on top of it. But you must take comprehensive insurance advice because this is complicated. This is the area where things go wrong. And this is also the area, if you're being honest, where things are most likely to cause a problem. Refurbishment works are more complicated and are more likely to have damage to pipes and fire than other jobs. Hopefully that's given you a little bit of background on option C, but the underlying message of option C is if you've got a contract that is an option C type contract, take detailed insurance advice. Make sure you're covered. Just going to briefly talk about RPA insurance. This is the risk protection arrangement insurance. This is very much aimed at public sector bodies and in particular schools. It originally came out to assist academies, but is now applicable to all forms of school who typically spend a lot of money on refurbishment works, new works. It is, in its general sense, I suspect, a very sensible policy. It can cover schools at a relatively low premium for what you might call standard risks. It is said to work for construction works that involve the school. The problem is it doesn't. To be brutally honest, it doesn't work for JCT. This is a very small worded slide, but this, if you go onto the government website and ask, look at the frequently asked questions, it says, does the RPA provide joint names cover or waive subrogation rights against contractors who damage existing structures? In other words, question 5 says, does it do what JCT requires it to do? And the answer is no. So if you are going to do works to a school, be it academy, local authority or anyone else, using the RPA insurance protection does not give you the correct cover. We have anecdotal evidence that people who try and then go to what's called the RPA risk plus policy find it very difficult to then get that insurance in any event. So the point about this slide really is that RPA insurance is not the solution to contractors or risk policies. You need to go and get a specialist policy, or again, as I've already explained, perhaps use the contractors or risk policy for the works and then get a specialist policy for the existing structures. Hopefully that made some sense. I mean, option C is very complicated and there's no point pretending it's not. The key point is to make sure you're aware of that and then take the correct advice. It's a bit like buses. We had a seminar on Tuesday for the civil engineering surveyors. We've got a webinar on Tuesday. We've got a webinar now, and we've got a seminar coming up on the 13th of October. Now, this is quite exciting because it means we can physically see human beings. So if you would like to come, there is the details of it. It's about insolvency, but really it's about what's going on in the market. We've got an insolvency practitioner who's going to be there and explain, where she sees the trends, where she sees, the particular pinch points in the market. So, and if nothing else, there'll be a free bacon sandwich. So after that, we're now going to answer some questions. We're going to have this rather false situation where I'm going to ask Carolyn the question, and she's going to give you the answer. So hopefully if we do this, I'm not quite sure how this is going to work. Oh, there we go. Perfect. There we go. So the first one, can you get, so we've got a number of questions on 651 insurance. And one of the questions is, can you get 651 insurance for the employer's own property if you are building next door? Carol.
You can. So ordinarily under a 651 policy, the policy will cover damage to the adjoining property, but you can also get policies that cover damage to the property that you are working on. It's a bit of a strange scenario to think about, really, that a property may effectively collapse, and that collapse not be due to negligence, because of course if there is any negligence, the policy will not kick in, but it does occur in certain circumstances, and you can get those policies for both the property you are working on and adjoining properties there too.
We've had a couple of questions on terrorism cover. As I've already explained, I think the terrorism cover, the default under JCT is you have to have terrorism cover. That, I think, is probably a bit out of date, and it really ought to be the other way around, where you don't have it, but you do have to have terrorism cover. There is also, the way JCT works is you are deemed to have pool recover, which is the government-backed scheme, unless it's specified as additional. Personally, unless you're in an area where you think it's a particularly big risk, I would be inclined to not require terrorism cover under a JCT policy, and just make that clear. It's a bit outdated, to be honest. We have a number of questions about levels of PI. What cover should we use for PI? So I'll put that to Carolyn first, and maybe I'll join in with it. But yeah, they're generally around people struggling to get the correct level, or understanding what level of PI they should have for certain size projects.
Yeah, it does ultimately depend on what you are doing and the nature of the project that you're working on. As a kind of rough guide, we tend to see PI levels averaging about 10 million. You'd never really see it going below 5 million, but we do see it going up to 20 million and beyond. The key, as I said previously, is that the policy is the right policy for you. So often you will want an each and every claim type policy rather than an aggregate policy, which will reduce if any claim is made. You also want to ensure that if you've got any liability cap, that your PI mirrors that, so there's no shortfall.
Yeah, and I think we have questions. If you've got a £10 million job, you don't necessarily need every one of your consultants to have £10 million PI. As Carolyn says, you don't find many consultants of any significant size who have less than 5 million in any event. But it's not always the case that the total cost of the works needs to be reflected in the PI. There just needs to be a risk assessment of quite exactly what could go wrong, what needs to be in place. It would be unfortunate to not have a designer that you want to have just because they've only got 5 million PI, when there seems to be an unrealistic assessment that they need 10 million. One other question is what is meant by the term prudent uninsured. I'll answer this, but what we often find is that when there is a problem, a large defect occurs and a claim's made on a PI policy, we often find we spend more time dealing with the insurer, trying to persuade them to provide cover, than we do the other side, who may be claiming it's our fault or it's not our fault or our client's fault. Prudent uninsured is essentially where the insurer refuses to cover you and you're still arguing about it. So you have to act as a prudent uninsured. So in other words, you have to do what is prudent to maintain the rights of the insurer. So that would be defending the claim, not admitting the claim. So all that really is a situation where you are still seeking to obtain confirmation from your insurers that you are insured. As I say, experience suggests that we spend more time arguing with the insurers than we do actually having the insurance taken on. We have had another question come in as well.
Yeah, it says, if my client cannot get option C existing insurances, then can we look to the contractor to cover and vary the contract accordingly via a change instruction? And that is on a residential conversion. I'll let you answer that one, Andrew.
I mean, the answer is yes, you can. I mean, what that says to me is it just reinforces the point that employers can't get option C existing structures insurance. It's just not something that the market is keen on. You can theoretically put it back on the contractor, but then you've got to ask yourself, can the contractor get existing structures option C insurance? So ultimately it comes down to there is a party of some description who currently insures the existing property. Maybe the employer, it may be a separate party. They are the ones who have to realistically take out this policy. It could involve the contractor, and it's entirely possible to put that risk on the contractor, but you've got to be realistic. Is the contractor in a position to actually obtain that policy? As I said before, option C, existing structures, is very complicated. There are some very good insurers out there who deal with that, but they are a bit like hen's teeth. So you need to find the right one for that. The answer is yes, but you've got to be realistic. Can the contractor actually obtain that policy? What you don't want is a contract where you are not covered for standard insurances. This we're at the hour mark. This is our first Teams webinar. We're learning, so we have this chat function down the side and stuff. So hopefully, if you were in on the call or on the webinar, then do let us have any feedback. Hopefully that came across okay. Don't forget that if you want to have a free bacon sandwich and actually meet human beings and learn about who's likely to go bust next, there is a seminar on the 13th of October. If you don't know how to find that link, go to our website, or this isn't really my strength, but I'm saying you can follow us or things like that. And that's it. So thanks very much for joining us, and hopefully we'll see you again soon, or speak to you again soon.
Yes, thanks very much, everybody. And thank you to whomever gave Andrew a thumbs up to his mods picture. I'm not sure he actually noticed when he was doing the presentation, but it did make me smile. So thank you for joining us, and we'll hopefully see you next month at our webinar.